Hi there, this is attorney Andy Marcantel from the Attorneys for Freedom Law Firm, and today I'm going to talk to you about your right to a speedy trial under Arizona law. Now, you've probably heard the old saying, we have a right to a speedy trial in this country. Well, it's true, but there's some interesting nuances that you should be aware of. So in Arizona, your right to a speedy trial is kind of encapsulated by Arizona Rule of Criminal Procedure, Rule 8. And if you take a look at Rule 8, it's got a bunch of rules about how your right to a speedy trial applies. Now, before we get into it, it's important not to confuse your right to a speedy trial with the statute of limitations for criminal cases in Arizona. Okay, well, what does that mean? Well, basically, depending on the type of case that the state brings against you in a criminal case, whether it's a felony or a misdemeanor, the state has certain timelines that they have to operate by, and they have a certain amount of time to charge you with these types of cases. So for example, with a misdemeanor, which are lower level offenses, they have a statute of limitations of 1 year to bring the charge against you from the date of the incident. And they can't bring it a day late, or else they violated the statute of limitations. On the other hand, if you're dealing with a felony, which is a much more serious offense, in Arizona they have 7 years to bring a felony charge against you from the date of the incident. Now in practice, normally the state doesn't take anywhere near the total statute of limitations to actually charge you, but just be aware that sometimes there are cases that can be stretched out for a long time, and they have 7 years to bring a serious felony charge against you. Okay, so you're now charged with the crime. They've now either indicted you or filed a complaint. How fast do they have to put on your trial according to the rules of criminal procedure in Arizona? Well, it's kind of a tricky question. So if you are in custody, then the state has 150 days from the date that you were indicted, so the date that they brought the charge, to put the case to trial. Whereas if you are out of custody, so you're released pre-trial and you're out there walking around in the world somewhere while your case is pending, okay, this is how most people are when they have a case in the criminal justice system, the state has 180 days to bring that case to trial. Now there are some kind of nuances with things called complex cases. In Arizona, sometimes the court will designate a case complex when there's a lot of discovery, or there's a lot of facts, or it's a long investigation spanning many years, or perhaps there's special experts that need to be used in your case. Well, in those types of cases, after the case has been designated complex, the state has 270 days total to bring your case to trial. And then the final category is capital cases. This is where the death penalty is alleged. They're obviously pretty rare, but in those types of cases, 18 months is the speedy trial rights of defendants under Arizona law. Now, there are many ways under Arizona law that those dates that I just gave you, the periods of time specified by statute in Rule 8, they can be extended. What are some of those ways? Well, sometimes the defendant willingly waives their right to a speedy trial, or at least pushes it back a certain amount of time that doesn't count against the state. So, for example, if a defendant wants a continuance to a hearing, they can say, okay, Judge, we'd like 30 more days to complete whatever we need to complete in our case. We'll waive time. Waiving time just basically means we're authorizing the state to lump on that additional time that we're waiving onto those timelines that I just mentioned earlier. So imagine, for example, I'm in custody. The state has 150 days after my indictment to put it to trial, but I want to bring in a special expert witness, or my attorney wants to bring in a very special facts witness or something like that that could seriously improve my situation. Well, at that point, if 30 days, for example, is the difference between me being able to get that extra witness or not, I might very willingly, as a defendant, say, you know what, I'm going to waive time. I'm going to waive 30 days of time to allow my attorney to go out into the world and maybe bring in a forensics expert, or bring in a character witness, or bring in a facts witness, bring in a special doctor or medical witness. These are very strategic decisions that you have to make, and it's very important that you have an attorney who understands these concepts, understands the right that you have as an American citizen to a speedy trial. And given how important that right is, you got to make sure your attorney knows when it's appropriate to waive time and when it's good to go in and demand that the state be held to its burden and give you a speedy trial. There are many other ways too under the law that time can be waived or time can be not counted against the state. They're more rare. It's things like competency hearings, for example, if the state is alleging that somebody is not competent to stand trial. Another example is if a case is remanded to the grand jury for lack of probable cause. And this leads me to something very important that I'm going to be making another video about. You guys can see the link in the description below, and I'm going to talk to you about what happens when you challenge the grand jury's findings. Now, this is kind of a complex subject, but it's very important that your attorney under Arizona law know how to challenge the grand jury proceeding itself. So make sure to visit that video as well. But that's another example of sometimes when time can be added to this calculation. So bottom line is you want to make sure to have an attorney who understands these important concepts under Arizona law, who demands the state be held to their burden to give you your right to a speedy trial, but at the same time knows when to strategically waive that time when it's in the best interest of the client. So I strongly encourage you to visit our website, attorneysforfreedom.com. Also check out the Attorneys on Retainer program while you're there to get our law firm on retainer to fight for you if you ever have any run-ins with the criminal justice system. Until next time, this has been Andy Marcantel. I'm an attorney and partner at the Attorneys for Freedom law firm. It's been a pleasure talking to you today. Thank you.